Legal Studies, Unit 3, Area of Study 1, the Criminal Justice System, Part 2. The focus of today's video will be dot points 3 and 4. The rights of an accused, including the right to be tried without unreasonable delay, the right to a fair hearing, and the right to trial by jury. And the rights of victims, including the right to give evidence as a vulnerable witness, the right to be informed about the proceedings, and the right to be informed of the likely release date of the accused. The rights of an accused are found in the Charter of Human Rights and Responsibilities Act 2006, Victoria. The purpose of this act is to protect and promote human rights in Victoria. Sections 23 to 27 protect the rights of an accused. All Victorian bills must be compatible with the Charter through a statement of compatibility issued before the second reading. Whilst the Supreme Court can declare that a law does not comply with the Charter, that does not mean that the law is invalid. The right to be tried without unreasonable delay. Time needs to be set aside for a full investigation to go ahead and for a court to hear all of the relevant evidence. In order for the presumption of innocence to be upheld, criminal matters should not be delayed. There is no definition, however, for the word unreasonable. The Criminal Procedures Act 2009 Victoria states that summary offences must be brought before the courts within 12 months, and matters against a child must be brought before the courts within 6 months. I have created this table which looks at the reasons for delays and the consequences of delays. So some reasons for delays could be the preparation of both cases, the collection of evidence. The court who is hearing the case may actually have a backlog of cases that it needs to hear prior to the case at hand, and the accused may still be determining their plea. Consequences of delays. The accused may be held in remand for a long period of time and then found not guilty. Witnesses may experience difficulty recalling certain events. The mental state of the accused may be at risk as they await trial, and the victim's family may be experiencing some hardships as well. The right to a fair hearing. A person charged with a criminal offence or a party to a civil proceeding has the right to have the charge or proceeding decided by a competent, independent and impartial court or tribunal after a fair and public hearing. Despite subsection 1, a court or tribunal may exclude members of media organisations or other persons of the general public from all or part of a hearing if permitted to do so by law other than this charter. As stated above, in some instances, for there to be a fair trial, the media does need to be excluded. There may also need to be a closed court, particularly if a child is involved, and if a witness is having difficulty giving a statement. The right to trial by jury. This right is protected by statute law and the Constitution. Section 80 of the Australian Constitution states that the trial on indictment of any offence against any law of the Commonwealth shall be by jury, and every such trial shall be held in the state where the offence was committed, and if the offence was not committed within any state, the trial shall be held at such place or places as the Parliament prescribes. Some concerns are that indictable offences are not defined, and Commonwealth offences are only mentioned, yet most crimes are state crimes. The Criminal Procedures Act 2009 Victoria, however, requires a trial by jury when the accused pleads not guilty to an indictable offence. As we have discussed previously, no jury is required for summary offences, and the Juries Act 2000 Victoria outlines how a jury is to be chosen. The rights of victims. The Victims Charter Act 2006 Victoria outlines the principles on how the criminal justice system and the agencies that work with victims of crime should respond to victims of crime, including investigatory agencies, prosecuting agencies, and victim services agencies. The right to give evidence as a vulnerable witness. Protections are offered because the formal environment of the courtroom may be intimidating for some, and this may make victims feel uncomfortable. It may impact the quality of the evidence that they give. Alternative arrangements can be made to assist those giving evidence. Individuals can be declared a protected witness, and children under 18 and those with a cognitive impairment are offered other arrangements. Alternative arrangements can be made for family violence offences and sexual offences, and this is to ensure that witnesses are protected from unnecessary contact with the accused, and it ensures the witness is not in a position where they feel intimidated to give reliable evidence. Some examples include having a support person when giving evidence, having a screen remove the accused from the direct line of vision of the witness, giving evidence via CCTV outside of the courtroom, or even closing the court to the public. Protected witnesses, particularly for family violence matters and sexual offence matters. Who can be a protected witness? The complainant's family member, the accused family member, or any witness that the court declares is a protected witness. During the cross-examination, witnesses cannot be cross-examined by the accused themselves. The cross-examination must be done by the accused's legal representative. If the accused does not have a legal representative, however, the court must order VLA to provide representation merely for the cross-examination. People with a cognitive impairment or children under the age of 18 can apply for sexual offence matters or offences involving assault or injury. The purpose is to acknowledge that those with a cognitive impairment and children are particularly vulnerable. It reduces the exposure of vulnerable witnesses to the accused and aids in eliminating the fear that witnesses may feel as a result of giving evidence. For sexual and family violence offences, further protections are available, including having a closed court, meaning that no unauthorised person is allowed in the courtroom, giving evidence via CCTV, having the accused be in another room when the complainant gives evidence, and ensuring that the accused does not see or hear the complainant when they give their evidence. Improper questions refer to questions that are of a confusing, harassing, intimidating, or offensive nature. The Evidence Act disallows improper questions during the cross-examination of a vulnerable witness. The right to be informed about proceedings. The process that happens after a crime is committed may be confusing for victims. Hence why the Victims' Charter requires victims to be informed about the investigation through investigatory agencies and prosecuting agencies. This ensures that the victim is not left in the dark and does not experience secondary victimization. The relevant clauses of the Victims' Charter are Clause 7, 8, 9, 10, and 11, which we will look at in detail. Clause 7, information to be given to persons adversely affected by crime. They are to be informed about available support services, legal requirements such as filling out forms, and available entitlements such as compensation. Clause 8, information to be given to victims about investigations. A victim must be informed about the progress of an investigation into a criminal offence unless A. The investigation is jeopardised if information is disclosed, or B. The victim requests not to be provided with any information. Clause 9. Information regarding prosecution. The following information should be given to the victim: the offences charged against the person. If no offence is charged, the reason why. If offences are charged, any decision to, for example, modify these charges or to accept a plea of guilty to a lesser charge. Details of an appeal and the outcome of the criminal proceeding. Clause 10. Applications. If requested by the victim, they should be provided with information regarding the outcome of any application for bail by the person accused of committing the criminal offence. If bail is granted, any conditions imposed on the accused person by the court that are intended to protect the victim or family members of the victim. Clause 11. Information about court processes. The victim is to be informed about the court process and the victim's entitlement to attend any relevant court proceedings. The right to be informed about the likely release date of the accused. The victim's register. Individuals who are victims of a violent crime can apply to be on the victim's register. Violent crimes can include sexual offences, assault, murder, manslaughter, armed robbery, or kidnapping. The victim's register provides information to the victim about the offender that was sent to prison. This information is confidential and the offender is not aware that information has been shared about them to the victim. The type of information that can be given to the victim includes the length of the sentence, the earliest possible release date, if the offender applies for parole, if the offender is released on parole, if the offender escapes prison, or if the offender dies during their sentence. Section 17 of the Victims Act states that a victim who is on the register can make a submission to the Adult Parole Board if it is considering the release of the offender on parole, outlining the effect that this decision will have on the victim and the ramifications it may impose. That concludes today's video on Legal Studies Unit 3, Area of Study 1, the Criminal Justice System Part 2. I hope that your knowledge of dot points 3 and 4 have been consolidated, and if you do have any questions, feel free to email me or leave them in the comments below. Thank you.